Hi, welcome to the Law Office of Justin Rosas. This month's video legal tip relates to felony sentencing and the Felony Sentencing Guidelines grid in the state of Oregon. We specialize in criminal defense throughout the entire region of Southern Oregon, and we give out a monthly tip just basically to describe some issue that relates to criminal defense or criminal prosecution within that region. The Felony Sentencing Guidelines grid is what determines what the presumptive sentences are for felonies within the state of Oregon. That means you're not stuck with what's in the Felony Sentencing Guidelines grid, but it provides guidance to the court. So if someone you know or you are convicted of a felony and you end up going to a sentencing hearing, this is what you can expect would be the likely punishment after a trial or after a plea to any major felony charge. Now, the Felony Sentencing Guidelines grid was born out of a federal Felony Sentencing Guidelines grid. And just in case you don't know, we have bifurcated court systems. Bifurcated is a lengthy lawyer term basically for saying we have a split court system. We have a state court system that enforces state laws. That's where things like DUI and other basic state crimes go down. And then in federal court, which we have actually a federal court here in Medford, the Southern District of Oregon is located in Medford. That's where usually larger quantities of drugs, firearms, illegal reentry, and other federal crimes are prosecuted. So back in the day, the federal government decided that sentences that were being handed out in one region were too different from sentences being handed out in another region, and they passed something called the Federal Sentencing Guidelines. Now, the Federal Sentencing Guidelines are several hundred pages, about 550 pages at this point, which have expanded greatly since their introduction. And they essentially relate a score to the seriousness of the crime and a score to the criminal history of the person charged with the crime. And then they use those scores to come up with a sentencing range. States like Oregon and many other states, once the federal government passed sentencing guidelines, came along. They didn't want to be the little brother, came along and passed their own sentencing guidelines. So that, for instance, sentences in Portland would be very similar to sentences in Lakeview. As you might imagine, things in Lakeview relating to firearms, for instance, were sentenced more leniently than things related to firearms in Portland, and things related to drugs in Portland were sentenced more leniently, perhaps, than things related to offenses related to drugs that happened down in Klamath County or Lake County. And we can see some of the social reasons why that would be the case. So, the state of Oregon passes what looks like essentially this, and I'll explain a little bit more about that in a minute. But as you can see, we have kind of a box here, a grid box that expresses both crime seriousness and the history of the individual charged. When Oregon passed those rules, the federal rules were still mandatory. Since then, there's been a Supreme Court case that came down and said you can't have a mandatory guideline. That means you can't take a judge's ability to give a lesser or greater sentence than a guideline away, or else you're violating due process. You're not giving a person the ability to adequately argue that the circumstances of their situation are different from the circumstances of the normal situation prescribed by the grid block. So the Oregon grid block describes sentencing categories from 1 to 11, 1 being the least serious, 11 being the most serious. The only 11 on our grid is murder. And things that fall within the 1 category are things like possession of a controlled substance in a user quantity, or bigamy. A few other sort of minor felonies end up fitting into crime seriousness level 1. We have I through A letters for the individual's criminal history that's being charged with a crime. And so I is no criminal history whatsoever. I is the least serious, I suppose. And then A is the most serious. And in order to be an A, you have to have 3 or more person-to-person convictions, person-to-person felony convictions. And person-to-person crimes, it sort of describes what it is. It's a crime that's either an assault, a sexual abuse, something that invades the sanctity of an individual's body or an individual's personal safety, not a theft or anything like that. So if you have those kinds of convictions, you can move over to be an A on the grid block. Then what you do is you take the crime seriousness level of the crime that you've been charged with, and you can look that up in a number of places, including on the internet. Obviously, my advice is to speak to an attorney to determine that. But I'm assuming that if you're watching this video, you may be interested in trying to figure out as much as you can as you get ready to talk to an attorney. And certainly finding that felony sentencing guidelines score is an important step in understanding whether or not what the presumptive sentence is going to be. You can also look on in Jackson County. You can look on an indictment, and you will see. So if you're charged with a crime, or someone you know is charged with a crime, and you can see their charging information or indictment, the list of charges that the district attorney has filed that they were given in court, you'll notice right next to the charge a caption that says FSG equals. That's felony sentencing guidelines score equals. Now they can get that wrong sometimes, but by and large it's usually right because it's a formula. And if you see that, you'll kind of know what the crime seriousness score is. Determining the criminal history of the person that you're trying to look up or determine what their sentence might be is a little bit more difficult, only because it's not so specific. It's not, as I show the grid, it's not something where it's either one number or another. It depends on the nature of the previous convictions, where they were, what state they were in, whether they were counseled, so whether the person had an attorney or not, because you can attack an uncounseled conviction and whether that should count for the grid. And so it's a little bit more esoteric, a inquiry to determine where somebody sits on the criminal history scale. Ultimately, I'm going to pull this back out and show it. I mean, ultimately, what you're doing is trying to determine whether you're in the pink, the purple, the green, or the yellow. And the numbers, which you can't see from this distance, the numbers go up quite a bit as you move towards, and I'm not very good at this, but as you move towards the top corner here, the 11A corner, which would be the most serious of both, the numbers get much larger. Now, in terms of reading the grid, the pink, purple, and green grid blocks are all presumptive probation grid blocks, and that means that it's presumed that a person that's convicted of one of those crimes is going to be given probation instead of being sent to prison. And the amount of time that a person's likely to get is described in those grid blocks. If you take the bottom number and you divide it by 3, and don't ask me why they set that up, but if you take the bottom number and you divide it by 3, that'll give you the likely number of days in custody that a person would serve if it was a presumptive sentence at the end of the process. Now, with a good attorney, a good investigation, hopefully you don't end up convicted of anything, and hopefully you don't end up in a sentencing position. But obviously there are cases where you do end up in a sentencing position, and it's a good idea to know what you're looking at and what the appropriate process is to keep it from being the presumptive sentence, to make it less. Now, making something less than a presumptive sentence means a downward departure. A downward, either durational or dispositional departure, is the process of giving a person a break from the presumptive sentence. And there are a number of reasons why downward departures are granted. Downward departures can be granted because of a treatment program. Downward departures can be granted because the harm was less than typical. Downward departures can be granted because of the fact that the victim played some role. Or a variety of other reasons. Now, the opposite thing can happen if the state files against you what's called an upward departure. That's where the state is asking for something longer than the presumptive sentence, and there are a lot more rules actually about when an upward departure can be appropriate, and many of those have to be proven to a jury. But an upward departure can increase the amount of time that a person's looking at by double. And so that can be substantial, particularly when you get into those yellow grid blocks. And those yellow grid blocks, the numbers there describe months in prison, and those are not presumptive probation grid blocks. So a person is presumed to end up in prison on those counts and end up with post-prison supervision or parole after they get out of prison. You can get a downward departure from a prison grid block to probation, so it's not impossible, and it's certainly something that happens with some regularity. But the presumptive sentence there for those yellow grid blocks is a prison sentence. There are a number of special rules with felony sentencing, and I should say this video is not a substitute for an analysis of what the presumptive sentence is in any particular case. You've got to get into a competent attorney, speak to them, figure out what the presumptive sentence is for your case, and fight the case as best as possible. But there are some special rules that I'll give just a few minutes to, and that is there's a repeat property offense rule, which basically says that if you've been convicted of certain types of theft or property offenses, burglary, robberies, then if you get another conviction or face another indictment for those types of offenses, you can be looking at a prison sentence even if your grid score falls into a probationary grid block. There's a repeat meth offender statute, which does something similar for people convicted of sort of commercial meth offenses on multiple occasions. There's also a repeat sex offender statute that if you get convicted of 3 felony sex offenses in your life, you do get a presumptive life sentence, actually, which is the most severe sentence that the state of Oregon hands out. So property crimes are also often based on the value of the thing that was stolen, and so the severity of a theft one, for instance, is greater if $150,000 were stolen than if $1,500 were stolen, even though both fit under the felony sentencing grid block. And those rules are laid out very specifically within the Oregon administrative rules that set up the grid block. The one other major element of felony sentencing that you're going to see in the state of Oregon in terms of the form of it is Measure 11. And we talked a little bit about Measure 11 last month, and I'd refer you to that video if you're interested in Measure 11. But the effect of Measure 11 on the grid block is that crimes that are Measure 11s do not fall on the grid block, and there is a mandatory minimum sentence for those crimes. And so if you're charged with a Measure 11 or someone you know is charged with a Measure 11, you don't look to the grid score, you look to the Measure 11 mandatory minimum sentence, and those are placed in a different spot on the grid. And again, there are some escape valves that can get a person back onto the grid, but that's the function of Measure 11. So again, the most important thing when you're facing a felony charge or someone you know is facing a felony charge in the state of Oregon is to know, to speak with a good attorney and to know your situation completely, to know about what suppression you have, what evidence issues you have, what defenses you have, what the possible sentences are. But it's also good to know these rules just to have some idea of what it is specifically that you would be looking at. For instance, in Jackson County or Southern Oregon, all possession of a controlled substance cases that are user quantities are level 1 offenses. And if you look at the grid block closely, you'll notice that I to A all get the same sentence on a level 1 offense. And that sentence is 18 months of supervised probation, 90 over 30 custody units, which equals 10 days in jail. And a lot of times those days are waived depending on the process. So those are sort of the presumptive sentences for the most frequent felonies, which are possession felonies. As you get up to level 4 felonies and higher, you start to get into serious conversations about the length of consequences. And of course, if you're above 7, so 8 through 11, everybody, including someone with no record, would be then facing a presumptive sentence of prison, which is a completely different set of problems and a completely different inquiry when you go through those types of cases. So there's a number of things that can be done, and certainly this view of felony sentencing is a rough outline of the possibilities that lay before a person charged with a felony. Again, my advice: get into a competent attorney, and deal with your case up front, deal with it as early as possible, and make sentencing arguments. If you do end up convicted, don't give up. I mean, if you end up losing a trial or you end up having to take some sort of deal, there are substantial differences between having a good attorney and between presenting a good sentencing argument and just laying down. So remember that, and next month we'll be back here. Thank you so much for watching, and this is the Law Office of Justin Rosas. Thank you.